The Archers is learning it.
It was indeed the Archers.
Thank you.
Thank you, my lord. Before we resume the discussion about fiduciary duties, I just wanted to step back one step and frame it. Also, just make it absolutely clear, because in advocating for an absence of fiduciary duties, I don't want to make it don't want it to be thought that what I'm advocating for in this place is some sort of laissez-faire, free-for-all, where the client has to fend entirely for themselves. It obviously isn't my case that solicitors don't owe ethical duties to potential clients when they're negotiating their terms of retainer, because they have those duties as members of a regulated profession. And it's quite clear the code of conduct applies to dealings with potential clients as well as actual clients, and that's the point I think that Mr Holland shows in his skeleton. So again, I don't want it to be thought that in advocating in one area for a duty which is not as the duty which the judge found, that I am suggesting that solicitors don't have very solemn duties to potential clients indeed, because that isn't our case. Obviously there are also freestanding protections from some of the scenarios that were put to me. In particular, the scenario, for example, my Lord the Master of the Rolls put to me about the city solicitor who says, well, they're happy to do the fast-track personal injury case for £1,000 an hour without telling the client that the recovery will be much less. That is the sort of thing that would fall precisely into the other rule we were looking at this morning about the requirement for informed approval of costs of an unusual nature or amount, which in consequence might not be recovered from the other side. So again, I'm not suggesting that answers any of the more difficult points that were being put to me about fiduciary duty, which I'm about to come to, but I did just want to step back and make those points about there being other sort of pieces on the chessboard, fiduciary duty aside.
Right. Helpful. Thank you.
Thank you.
Can I just tell you where I've been going over the short adjournment? Looking at the law according to Lord Leggatt in relation to relational contracts and the duty of good faith, it seems from my limited researches over the adjournment that he is talking about a duty of good faith owed in the performance rather than negotiation of the contract. And the duty as regards in negotiation, he says, arises under the Napoleonic Code, but does not arise in English law at the moment, as far as I can
Yes.
tell, even in terms of a relational contract, which this could be said to be because it's a fairly fluid definition. The other point is that when you consider whether or not this is a fiduciary duty situation, you have to consider what is the fiduciary situation, what is the fiduciary duty that is alleged to have been breached. And if you look at Mothew, Lord Millett at page 18, Lord Justice Millett said, a fiduciary must act in good faith. He must not make a profit out of his trust. He must not place himself in a position where his duty and interest may conflict. He may not act for his own benefit or for the benefit of a third person without the informed consent of his principal. Now, what seemingly is being said here is that the fiduciary duty in question is making a benefit or receiving a benefit by negotiating an inappropriate fee at a greater rate than should have been negotiated without the informed consent of the principal. But I suppose this is where I've got to. I suppose the answer that you give to that is, well, if you have agreed that you're going to enter into a open market negotiation as to the rates of pay, absent the case of charging £1,000, which is dealt with either by 46.93 or by informed approval being necessary for an exceptional fee, or it's dealt with by the code of conduct, you actually agree that within the normal bounds of negotiation, you will negotiate in your own interests.
Yes.
And you can't say that fiduciary duty, even if it exists, is engaged. But
well, by definition, you can't be in a situation where the duty and his own interests conflict, because by definition he's acting in his own interests in negotiating the retainer.
With respect, it's interesting that your lordship went back to Mothview, because I was actually going to next show you quite what I would characterise as a useful recent synthesis by Lady Arden of the principles, in which obviously she starts with the Mothview, and that synthesis also makes it clear that you do have to look very closely at the context in which the transaction is occurring in order to discern the scope of any, whether a fiduciary duty arises at all, and if so, as to its scope.
Is that children's investment?
It's children's investments.
Which Lady Arden wasn't, I think, in the majority.
It's a unanimous court, but there is I think Lord Wilson, Lord Briggs, and a third member. They agree with her on most of what she says, but they take a different view on something else. But I was going to take you to really the synthesis of the fiduciary principles rather than the actual disposition of the case itself. But your lordship's quite right. And there's a sort of dubitante, but not quite a dissent from Lord Reed at the end, as I recall. In our bundle,
it was a great case. It was a great case, Mr.
Williams. Was your lordship
I was
Chancellor?
reinstated.
Yes. I guess.
Pleasant experiences, aren't they?
Yes. I assumed that it was your lordship as Chancellor, but I'm not sure that was completely clear from the bits I revisited over the shorter journey. So,
it's all right. I don't have often the opportunity to grow in that direction.
Well, anything I can do to improve my staff.
Should we look at it?
It's an entirely cynical ploy, my lord, to achieve that. So I was going to show you, as I've said, this passage of synthesis, which begins, it's page 1163 of the paper bundle, 1164 of the PDF. And it's paragraph 44. 44. So she says there's been a considerable debate about how to define a fiduciary, but it's generally accepted today that the key principle is that a fiduciary acts for and only for another. He owes essentially the duty of single-minded loyalty to his beneficiary, meaning that he cannot exercise any power so as to benefit himself. And there's the extended and now celebrated citation from Lord Justice Millett, which says what we all know it says. And as your lordship has already divined, we would say that a number of those characteristics which are there identified are characteristics which somebody negotiating their own terms of remuneration would find it very difficult to honour. And then Lady Arden continues, so the distinguishing obligation of a fiduciary is that he must act only for the benefit of another in matters covered by his fiduciary duty. Obviously that's just only for the benefit of another. That means he cannot at the same time act for himself. 46, if a person is a fiduciary, then as part of his core responsibility, he must not put himself into a position where his interest and that of the beneficiary conflict. That's the no conflict principle. And he must not make a profit out of his trust. Again, that's really just paraphrasing Lord Justice Millett. And then at 47, there is a citation of the Court of Appeal's approach, which I don't think is disapproved, notwithstanding the difference in the result. So the Court of Appeal adopted the Federal Court of Australia in the Grimaldi case. A person will be in a fiduciary relationship with another when and insofar as that person has undertaken to perform such a function for, has assumed such a responsibility to another, as would thereby reasonably entitle that other to expect that he or she will act in that other's interest to the exclusion of his or her own interest or third party's interests. This formulation introduces the additional concept of reasonable, and this is, if I can respectfully say so, a rather nice phrase, the additional concept of the reasonable expectation of abnegation of self-interest. Reasonable expectation may not be appropriate in every case, but it's with that qualification consistent with a duty of single-minded loyalty. So a potential test of is the scenario as such where one would have a reasonable expectation of abnegation of self-interest. And then lastly, in this synthesis, if I could just turn over the page to paragraphs 50 to paragraph 51, where there is a citation of Mr Justice Sales, which in my respectful submission is also helpful. A person, this is still Lady Arden, a person can be a fiduciary in relation to another party with whom he has a contractual obligation in respect of some only of his contractual obligations, and there's a citation. This is only one of the situations in which a fiduciary duty may arise. It is important to examine the very specific context in which it is said that a fiduciary duty arises. This point was made by Mr Justice Sales in the Bartholomew case. The touchstone is to ask what obligations of the fiduciary character may reasonably be expected to apply in the particular context where the contract between the parties will usually provide the major part of the contextual framework in which that question arises. So that obviously introduces the concept of looking at the particular context alongside the contract itself, and here of course there wasn't yet one, as to whether or not a fiduciary duty has interposed, for want of a better term. And just to take up, I hope quite briefly, this morning's discussion from that, we do say that none of that is consistent with a party having a duty to self-abnegate when they're stipulating for their own terms. It may very well be the answer that is different if part of the stipulation which is going on is something which is essentially fraudulent, like a concealed submission. But when you are just having, subject to the ethical duties imposed by the regulator, a free market negotiation of commercial terms, and obviously I appreciate that as between Ms Belsner and a firm of solicitors, there is not, this is not two commercial parties arguing from a position of equality. But equally, this is hardly a scenario of high-pressure selling. Everything is sent in the post. No one is standing over Ms Belsner, pressurising her to decide whether or not to proceed with the transaction. It's against. So it's in my submission that the appreciation that this is ultimately a contextual question is helpful in unlocking this. And if I go to the point put to me by my Lord Justice Nugee before the short adjournment as to, well, where does the timing come into this? I would respectfully suggest that the timing is part of the context in two ways. Firstly, insofar as the fiduciary arrangement arises out of the contract, then the fact the contract doesn't yet exist and is the very thing being negotiated. It's obviously part of the context, and timing is just an incident of that. It's before the contract. And it's also relevant just to the context of asking, well, what is there a reasonable expectation at this punctum temporis, at this point in time, of a self-abnegation? And in our respectful submission, there wouldn't be when one is negotiating one's own terms of retainer. And although, of course, I've already recognised that Lord Neuberger in the Motto case is not as transfigurative as it might first appear, because, of course, he's not concerned with fiduciary questions at all. He's just asking a more narrow contractual question about, is the client liable to pay for the sort of work, because I think the solicitor purportedly charged the client for putting in place their own contract. So he's analysing it through a different lens, as it were. But the basic point that he makes, in my respectful submission, interfaces quite neatly with this question of you have to look at the context and ask, in that context, is there a reasonable expectation of self-abnegation? In that context, is there a fiduciary, not only a fiduciary relationship, but even if there is one, is it one for which this particular event is within the scope of it? And in our respectful submission, when it comes to negotiating the initial terms of retainer, that's not the position. And insofar...
And also the suggestion that there's a fiduciary obligation in the context of the negotiations between the solicitor and the client, outside the fraud example, does rather cut across the contractual scheme, as it were, because this is not a contract of utmost good faith.
No.
I mean, the categories of contracts of utmost good faith are pretty circumscribed, and obviously insurance, suretyship. But I don't think anybody's ever suggested that a contract between solicitor and client is a contract of utmost good faith.
No, I was just looking at Mr. Holland, because I know he's been involved in a case involving Candy, which I think there was some debate about whether the client owed a duty of utmost good faith, but I could be wrong.
Not about that.
No.
I'll mention that briefly when I...
Yeah.
I'm obliged. Well, I will yield to Mr Holland on some of these points because I think he's recently been arguing.
I only
something,
make,
but,
we would, one of the things that the court was discussing earlier, but I think it's I'm pretty certain that unless the law has moved on very considerably since the last time I looked at it, and I don't believe it has, that the categories of contracts of utmost good faith are fairly...
generally regarded as established.
Well, it's insurance and a few other...
Yes.
Suretyship and...
Yes. Yes. Quite. So far as...
Can I just pick
yes,
up this point about timing? Going back to an example which was raised this morning, there's an existing retainer. The solicitor has been engaged for a piece of litigation and then wants to renegotiate the hourly rate, which in a long-running piece of litigation is entirely understandable. But you don't have a timing point then, because there is an existing relationship. There is an existing retainer. Is the duty different?
Well, in my submission, I mean, that would be an answer again as to, in those events, would there be a reasonable expectation of self-abnegation? Now, obviously, and it may be sort of quite a nuanced question. I mean, if, for example, the solicitor had no contractual right, essentially there was simply no right under the contract to stipulate for a higher fee. It might well be before the negotiation commenced, the fiduciary duty would oblige the solicitor to point that out. But if the client were to say in those circumstances, look, I'm a reasonable person, and I recognise we've had a completely unexpected hammer blow of inflation because, you know, for example, as a fanciful example, some reckless fiscal event, so I am willing to enter into a negotiation with you. Then at the point that they agree to enter into a negotiation, then in that negotiation there might not be, or there would not be, a reasonable expectation of self-abnegation.
But this seems quite a difficult test. You know, if you ask a client at the outset of litigation, and the solicitor said my hourly rate is £250 an hour or whatever, if you ask the client what happens if it lasts for more than a year, do you expect the solicitor can put their fees up? The client is likely to say, well, that's a matter of law. I would expect my lawyer to tell me whether they can put their fees up halfway through the case. And it may be quite a difficult question because you can't just sort of threaten to leave a client in the lurch halfway through a bit of litigation. There may well be constraints on whether you can or can't.
In that example, of course, it might not turn on a negotiation as such. It might be the solicitor asserting, I have an implied right to do this, and whether that's right or wrong is a question of law which isn't influenced by the fiduciary nature of the relationship.
But it seems quite a fragile test to say, would the client think that the solicitor was going to self-abnegation? Or would the client think that halfway through his or her case, the solicitor could threaten that unless you agree to increased hourly rates, I'm going to drop your case? I mean, the client probably wouldn't have any expectations one way or the other. They would just expect their solicitor to see their case through to the end without thinking about inflation.
It may be that perhaps Mr Holland might be able to help on this one. I mean, I simply don't know whether in complex litigation, solicitors' retainers include provisions that allow for an increase of the rate of fees if the case goes on for a long time.
I think they normally do.
I would have thought they do.
The only thing that pings up in my brain is there's a case called Candy and Crumpler, which I was involved in, which was this court, 2020 EWCA Civ 26, was argued in the Supreme Court earlier this year.
You haven't had judgment yet?
Haven't had judgment yet. And that was a case, it involves whether a solicitor loses their lien or not by failing expressly to retain it. And that was a case where there was an existing retainer, and the solicitor said, we're going to enter into a wholly new arrangement. And the courts below and the Court of Appeal held that they thereby, without expressly retaining the lien, they had abnegated it. They got rid of it. And the reason for that is said to be the solicitor's fiduciary duty to the client to explain why. So it's not bang on point, but there is some learning in that case as to there would appear in that case where you said if there is an existing retainer
Yes.
then is there a fiduciary duty in respect of a new retainer or an amended retainer? Well, then yes, there is some learning to say yes, there is, certainly in relation to the solicitor's lien.
Can we see the Court of Appeal in Candy and Crumpler, please? Is it in the bundle?
It's not in the bundle. I didn't.
Can we see it? And
yes, absolutely.
to be given some idea when you expect. Obviously, you don't know when you might expect the Supreme Court decision.
You better ask Lord Briggs. I think.
How long since the hearing?
It was March. It's been some months. It's been 6 months, I think.
Okay.
I mean, can we just also put out of our minds the words reasonable expectation of abnegation of self-interest? I don't find that common language, and I find it very difficult to understand. I think what Lady Arden meant to say was that there was a reasonable expectation that the fiduciary would not act in their own interests. I don't think the word abnegation is useful in 2022, yes. And I think it confuses what we're talking about. And the question is whether in relation to the contract that the solicitor and the client are entering into, there is a duty on the solicitor to obtain fully informed consent to the fact that the costs may exceed the amount recovered. Now, where does that come out of fiduciary duties?
Well, indeed, and what I would also say is, firstly, one has to assume that if there is such a duty, then presumably it applies in all litigation cases where there might be some expectation of costs being recovered, not just fixed cost cases.
That particular alleged fiduciary duty, it's got nothing to do with the solicitor acting in his own interest against the client's interest at all.
That sounds more like just giving negligent advice.
It's effectively failing to paint the full picture.
Exactly, which for our part
which is a completely different thing altogether. It's not to do with conflicts of interest or acting against the interests of the client, because what the solicitor's charging remains completely unchanged. What the complaint is,
exactly. You
didn't say to us that what you were charging, which we've never complained about as such, was 5 times more than
exactly. So I mean, what we're saying is this is the field of professional negligence or regulatory law. And if you perhaps think about a case that's not a CFA, you have a solicitor that doesn't explain to their client that in England and Wales, if you lose, you pay the other side's costs. Now that's a pretty important piece of information. But it wouldn't be a breach of fiduciary duty not to give it. It would be an open and shut case of professional negligence unless you had no reason to be on notice, so your client didn't already know that. But if your client was an Italian, for example, or an American who came from a non-cost shifting jurisdiction, but nobody would suggest that fiduciary duty is the key to unlock that conundrum.
Where solicitors do owe fiduciary duty, I mean, the classic case is Nocton and Lord Ashburton's, when you're negotiating with the client, not for a fee, but for some other...
A transaction.
Some transaction, and you know something as a solicitor, which the client doesn't know, and you don't tell the client. And there is an obligation of informed consent, because you've got to tell the client what you know about the transaction, because otherwise you're taking advantage of your own client.
That's certainly the case. And there's also, I think, there's a concept that may well be members of the court know much more about than I, that's quite closely related to fiduciary duty, called breach of confidence. Obviously not confidentiality, but breach of confidence, where again the problem.
But that's a rather different thing.
Yes.
I mean, Nocton and Lord Ashburton is the locus classicus for the duty to disclose. That's why you say that solicitors are fiduciaries who have a duty to obtain fully informed consent before their client is signed up to a transaction that benefits the solicitor. But I think your point is that when all you're doing is saying this is what I'm proposing to charge you by way of costs, you're not in similar territory.
Indeed, and what we have done is we have left out a relevant piece of, on a worst case, we've left out, and assuming that, as I think it might be a fairly safe assumption for some of the exchanges with the bench, it's felt that the contractual documentation is imperfect. I've accepted it's imperfect. We've left out a relevant piece of information. That in our submission is a scenario, it's unfortunate, and if it happens and it occasions the client loss, then it is perfectly adequately catered for by familiar common law remedy of damages, to say nothing of the superaddition of the rights to go to the SRA or the Ombudsman because of inadequate professional services. But to use a cliche I used in a different context, it's again square pegs and round holes to be introducing, in my respectful submission, a fiduciary analysis into this, particularly one that's founded on cases which are essentially cases of fraud, which is what we've seen.
I don't think Nocton and Lord Ashburton was a case of fraud, and you don't need to allege fraud if what you're alleging is that the solicitor knew something about a bit of property and didn't tell me.
Yes.
Non-disclosure of that sort.
It's certainly a case of maybe false is wrong word, but it's certainly, in my respectful submission, of a case in which there was an absence of the complete good faith which one is expected to receive once the fiduciary relationship has started.
Yes, I'm still slightly hesitant about you putting so much emphasis on the timing point, because I think if you, it's quite unlikely to happen in practice, but if at the very outset of the retainer you had a Nocton and Lord Ashburton situation in which the solicitor stipulated as part of the terms on which they would act for the client that there would be a side transaction, I can't believe that would stand if a solicitor suppressed some information.
Well, that may well take us back to the sort of contextual.
Yes.
Yes. I wouldn't advocate that, and in this case, I clearly, with respect, I submit I clearly don't need to advocate anything like that.
It takes us back into the secret profit area, really. I mean, it's effectively a more sophisticated form of secret profit through a transaction about which you don't disclose the full picture, and that is potentially a breach of fiduciary duty. But as you say, this has just got, it's a million miles from that.
Well, that's my submission.
I mean, have we got to this position? You do not say that a solicitor can never owe a client a fiduciary duty in the course of a negotiation for a retainer. But you do say that in order to identify what fiduciary duties are owed in that context, you have to look at what is being done and what is the nature of the duty allegedly owed. And here, the duty allegedly owed is that the solicitor will obtain fully informed consent to the fact that the costs may exceed the recovery, which has actually nothing to do with the question of whether he's acting in his own interests or in breach of his duty of loyalty. It's a matter of fully informed consent, which would only arise either under 46.93, where statute provides for it, or in a contract uberemi fide of utmost good faith, which this contract is not.
Yes.
And so it's a, if you like, it's a good try to say that there are fiduciary duties, but it doesn't actually get home in the way that I've just put it. Now, Mr. Kirby may say, well, you've put it wrong. You're not putting my case in the way I want to put it. So we need to hear in due course what he's got to say. But that is the way I understand your responses to the court.
Yes, there is, however, just one last aspect of it, which is, as we've seen, the judge, and he showed you the passage earlier, he having articulated a breach of fiduciary duty, he also then takes the approach that if there is such a duty of fiduciary duty and it's breached, that essentially vitiates what I'll call the Section 74(3) agreement. So it's not valid and enforceable, because you'll remember that he says the agreement has to be valid and enforceable. And he gives the example of an agreement which could be might have been induced by misrepresentation. I'm not sure that's a very good example, because that would merely be rescindable. It wouldn't be invalid and unenforceable. But that's what he says. And he essentially goes on to equate an agreement which has been procured without fully informed consent as an agreement which is unenforceable. In our respectful submission, that's not correct That's not correct either. It doesn't render a transaction unenforceable, but it does potentially give the client a right to remedies. It might, for example, give a right to rescission, but then there would need to be counter restitution, for example, of the benefits received. So there are certainly certain circumstances in which there have been breaches of fiduciary duty not involving bad faith, where it has certainly been held that the client is still liable to pay a reasonable remuneration. And of course, there could be equitable compensation, for example, if the client has suffered detriment. But and I know it goes back to my leitmotif, the answer to all of this in our respect, which is the client has not suffered detriment. There is nothing that would make it proportionate for her to rescind, quite apart from the effluxion of time and the fact she hasn't purported to rescind thus far.
It involves the proposition that the whole retainer, the contract, falls away, that it's somehow unenforceable.
Well, the learned...
There's no question of severance.
Well, I was going to say, the learned judge almost seems to reverse severed, where he's just treated one element within the contract of what I call
capable of being
as capable of unenforceable, and you just ignore it. I mean, if you well, you don't even just ignore it, do you? Because you therefore have to substitute a sort of implied agreement that well, I suppose once this comes out, he says that Section 74(3) stops the recovery. So once you've deleted the provisions that say things like if there's a shortfall, you pay the difference. That if those are ineffective, then Section 74(3) supplies the answer. Yeah. But in our position, that too is a non sequitur, because you cannot equate a breach of fiduciary duty with the sort of statutory unenforceability of the sort you might have in a consumer protection statute like the Consumer Credit Act as was. Now in our skeleton we cite some extracts from Snell and such like, which we can turn up if we need to, but the sort of basic proposition that at most you might have a right to rescission, and even if you exercise that right you would have to give restitution for the benefits received. And we don't see why giving restitution for the benefits received wouldn't be the £800 odd, of which £500 has come from the opponent.
Yeah.
Mr Kirby also has a point that, well, in fact, performance in this case had theoretically started because the client approved the claims notification form being submitted before she got the documents in the post. We address that in our skeleton, and I hope, at least, however I put it in writing, that during the course of this debate with the bench, I have not put all my eggs into a timing basket anyway. So in our respectful submission, that point just isn't a dispositive point. Then the last point we had before the Consumer Rights Act is the question as to whether informed consent has in fact has nonetheless been given to the deduction that was in fact made. And all we say about this is whatever the inadequacies of what the client was told, which we've accepted are imperfect. She was certainly told there would be deductions. She was told that for the success fee alone there might be a deduction of 25%. She was told there was at least a risk of deductions for basic charges on top of the success fee. And in one of the provisions we looked at this morning, she was even told that if the case went on to small claims, I think it was a paragraph the Master of the Rolls, my Lord the Master of the Rolls pointed out to me, that in that case they would limit their remuneration to 25%? To £500. £500, which of course
half of
yes,
1,000. Yeah.
Which of course is less than the which is less than they actually charged her on top of the inter partes costs for a case that didn't go to the small claims track. So I suppose this interfaces with my leitmotif, as I call it throughout, that Ms Belsner has not suffered detriment, because whatever, clearly there may be, if informed consent is relevant, and my solicitors had attempted to charge her the £2,500, then there might be a very strong argument she hadn't given informed consent to that. But has she given informed consent to that which she was actually charged in circumstances where it was less than she was told might be deducted for the success fee alone? And our submission is that she has given that informed consent. My Lord, so that leaves the respondent notice points under the Consumer Rights Act. It was previously agreed between Mr Kirby and myself that I would essentially anticipate his case on that, but clearly the forensic shape of the case does not taken the form that he and I anticipated when we agreed the timetable, for example. I'm very happy to address you on that now, but it might be that since they're actually his points, you might prefer that we dealt with them in reply.
Well, I mean, the Consumer Rights Act point, I mean, you have one point, don't you? You say it's simply misconceived. Is that, am I correct in understanding that?
Well, I don't think it's. I mean, our first point is, well, it's misconceived because the consumer, one of the implied terms of.
Well, it's misconceived. I'm sorry, misconceived if Section 74(3) doesn't apply.
If Section 74(3) doesn't apply, then yes, the point's valid.
Because it's all sprung.
Yes.
I mean, their submission is. I mean, I'm just looking at it in their 170 of their skeleton. The term as to recovery of costs over and above fixed costs creates a significant imbalance to the client's detriment. That's the test, statutory test. Because it results in a liability for base costs of a sum greatly in excess of the fixed maximum allowed under 74(3). Well, 74(3 is wrong, that's wrong.
Exactly. So they're saying.
And then the consequent use of base costs as the multiplicand, well, that's the same point. And the fact of statutory protection provided by 74(3, sorry, in both cases without mentioning the fact of statutory protection. So if there is no statutory protection,
the point is exploded.
the point doesn't run.
Indeed, we would have some other points as well, but maybe those are better left for reply.
Well, I mean, they've got to get over 74(3, haven't they? To
They
get
have.
into the other points.
That's quite right.
So it's not a freestanding point.
It's not a freestanding
No. It is another way of trying to remove the contracting out. But if the contracting out is irrelevant because Section 74(3) never applied, then whether or not it simply doesn't matter.
And then they've still got to get over the transparency and so on.
And the core exemption point.
Yes, there's a core exemption, but then there's also, yes, there's no evidence, despite the fact that all the circumstances have to be taken into account. And also, ultimately, as we all agree, a solicitor's ultimate right to remuneration is a right to reasonable remuneration, supervised by ombudsman and judge. And since the Consumer Rights Act itself implies into every contract of services a right to reasonable remuneration, and our respectful submission is quite
Circular argument.
It's quite difficult to see that there is anything unfair that has gone on.
Okay. Good. Well, you'll deal with that in reply.
As it please your lordship. Well, unless I can assist the bench further, those are my
Very helpful.
submissions.
Thank you, Mr. Yes. Yes, over to you, Mr. Holland.
My lords, I'm going to start, if I may, with some general points about solicitors and the personal injury market. I'm then going to deal with some general points about this case and other cases, and then certain specific points on the law. And I have it in mind to deal with the fiduciary duty point, albeit what I'm saying is almost identical to what Mr. Williams has been saying. Some general points. The solicitor's profession in England and Wales is very highly regulated. There's the Solicitors Act 1974, the Legal Services Act 2007, there's the Solicitors Regulatory Authority Code of Conduct, there's the Legal Ombudsman. In addition, there are the consumer law, and we've set those various rights out of paragraph 53 of our submissions. I won't go into them now, but the Consumer Rights Act does apply, we accept that. There's common
Can
law.
I just ask you,
Yes.
is the code of conduct made under statute? Is it?
Yes, it's made, I think what has happened, I think we explained at the beginning, originally the Law Society was in charge of it, but we have subcontracted that out to the Solicitors Regulatory Authority.
That's divorce the...
Yes, in the same way as the Bar Council now doesn't do bar. So yes, it is. It's a statutory.
It's under the Legal Services Act 2007, which now makes you the frontline regulator.
Yes, and we, I think originally there was provision under the Solicitors Act, but it's now, I think, yes.
Sorry, it
everyone's
makes
up.
the SRA the front line.
Yes, yes.
And does the statute, does the Legal Services Act indicate what the remedies are for breaches of code?
Well, there's disciplinary sanctions. I don't have them off the top, but there are disciplinary sanctions. And indeed, there is the general, the last part I was going to mention was that they're officers of the court, and my lord, the master of the rolls, is ultimately that particular avenue of disciplinary sanction. But yes, there's the Solicitors Disciplinary Tribunal,
Yes.
which...
I'm not quite sure I am anymore, actually, Mr Holland. I think my duty is to appoint the Solicitors Disciplinary Tribunal, but I don't have any personal disciplinary responsibility for solicitors anymore. But
you have subcontracted that out.
save insofar as I appoint the SVT, I may have some other duties because I still get surprised by the duties I do have. But
I'm grateful. They are officers of the court, though. In a way, I think that the members of the bar are not. And then there's common law. Those aren't duties, but as my learned friend Mr Williams has pointed out, it's a case called Turner and Palomo. Even if you're not entitled to anything other than reasonable fees, even if the client has missed all the deadlines under the Solicitors Act for detailed assessment, if the solicitor sues, they're still only entitled to reasonable fees. And that's a case where solicitor tried to, for summary judgment, and it was said, no, you don't get your bill, despite the fact that the time limits have expired. It's reasonable fees, and that's what you get.
what's the reference for that case? Is it in the bundle?
I'll get it for you. It's quite well known. It's 19. I will get it for you.
Being well known doesn't make me aware of it.
I think there's I think the principles of synthesizing one of the other cases.
I'm pointing out Section 31 of the Solicitors Act is the relevant provision of the 1974 Act, which deals with the discipline, and that's we delegate onto that. But my Lord the Master Rules is of course correct. There extra provision under the Legal Services Act. In that landscape, the Society sees neither scope nor need for any innovative judicial intervention, given the panoply of regulation and consumer protection which Parliament has seen fit to impose over the years. The next point, I think I refer to Mr Dixon's statement, and as Mr Williams has pointed out, certainly so far as personal injury work is concerned, over the last 20 to 25 years, there's been a constantly changing legal landscape to which solicitors have had to adapt. One starts off with the Section 58 of the Courts and Legal Services Act 1990. As Mr Williams points out, CFAs were originally introduced in 1995, but not commonly so until the Big Bang, as it were, in 1999. One then, where in fact legal aid was swept away for personal injury work, and solicitors were expected to work under arrangements which had, until comparatively recently, been seen to be unlawful. We're followed by the so-called costs wars Mark I, to do with battles between claimant solicitors and defendants insurers as to legality. I'm grateful. I'll deal with that yet. That caused the abolition in 2005 of the regulations in respect of CFAs which had been propounded in 2000, and then in the 1st of April 2013 we had the Panoply of Jackson reforms, and in the meantime, going on in the background, we have the expansion of fixed costs and pre-action protocols, and now from the 31st of May last year we have the expansion of the small claims track, which effectively takes a large chunk, if not most, of personal injury work outside any cost-shifting jurisdiction at all. Because the personal injury limit is for road traffic claims is £5,000, and the vast majority of road traffic claims, indeed the vast majority of personal injury claims, are under that level, and your litigants are compelled to do that. Well, they're said to do it in person.
This is the whiplash portal.
That's right. Well, there's also, it applies to all other personal injury
Yes.
claims as well, and you don't get any legal fees at all. But as Mr Dixon says, the evidence so far is that most people do use solicitor services when it comes to dealing with that.
You don't get any fixed costs at all.
No. You get issue fees, you don't get any legal costs. I'll give you it. But that's the landscape.
And presumably, solicitors who act for clients in those cases do tell the clients you won't get anything back from the other side in respect of our costs.
Yes, they'd have to.
Yeah.
I think. I mean, well, now on the other hand, what concerns the society is also now there is an expansion of the fixed costs regime, and indeed it may be that there will be an expansion of fixed recoverable costs to cases which up to £100,000.
But I thought Mr Dixon told us that 90% of clients bringing claims through the Whiplash portal were represented.
Yes, they were. That's the point. But they're representing circumstances where they have to pay their own legal fees. They're not going to get any legal fees back from the other side.
No. And you said accept issue fees, but there's no issue fee.
Well, sorry, you may get, I haven't got it off the top, but there may be expenses that you get, but you're not getting any solicitors.
You get a medical report.
Yes, yes, but you don't
Because
get
you can't actually get compensation until you've got a medical report.
That's right, yeah.
So you don't get base costs.
No, you get nothing.
Which means that the costs, if you use a lawyer, have to come out of your damages.
That's right. This case, I think, would now be in the small claims track, therefore.
Maybe not, because it's a motorcycle.
Ah, right, yes. While
Sorry, I didn't hear what Mr. Williams...
I said we'd need to check because there are different rules for motorcyclists than there are for car drivers, believe it or not. It's a very complex system. I can't, off the top of my head, remember. But there are certainly different rules for motorcyclists.
my learned junior, Mr. Cohen, who's not yet here, wrote it all out for me. And if you want, I'll write out exactly what, because I think there's 3 different systems for.
Well, I think it would be useful actually, because although I was responsible for making those regulations, I maybe haven't grasped the finer points of mine.
Yes, but my impression is now, is that the large chunks of personal injury work have no recoverable legal costs, and the litigants are expected to do it themselves.
If it assists, it's confirmed from behind that motorcyclists have been deemed vulnerable road users, and so they still get costs subject to the old £1,000 small claims limit.
Thank you. And as Mr. Dixon explains, my point was that the constantly changing landscape into which solicitors that is that these have had profound changes on the way solicitors have done business. Gone are the days when you'd have a high street firm, you'd walk in and say, "Oh, I've damaged my leg at work. Can you please represent me? Or we'll get you some legal aid, and then we'll the only way to make money out of this is bulk practice. Is to have systems and employees at a level whereby you can, I won't say pile them high and sell them cheap, because that would be unfair and inaccurate, but it's that idea. It's bulk work is what needs to
And you use paralegals to write
Yes.
the letters, not
Yes.
fee-earning partners.
That's right. Or you punch a computer and the standard form letter with the relevant client name comes out. I don't know the exact date. But it's bulk handling of commoditised claims by non-qualified or low-grade staff. Remote contact with clients is the norm. Ms Belsner would not expect to come in and have a meeting face-to-face with the solicitor, who may be, and probably is, in a completely different part of the country.
Can it all be done by AI? I mean, why?
It may be in the future. I don't know. I'm not a.
No, but if you're a solicitor, I mean.
Well,
What I'm concerned about is the presumption of the Whiplash portal.
Yeah.
Is that the clients do it themselves. That they go on the Whiplash portal. I mean, I've been on it myself. I expect you have. You sign in, and it says who are you, and all those questions, and all you have to say is where you had the accident, etc., etc., etc. you really don't need a solicitor. Now, if a solicitor is doing it for you, once you've given the data, and you know the solicitor knows what the data is, the data is date of accident, name, address, car number, blah, blah, blah. I mean, that's all stuff that can be done automatically.
My lord, the point of my submissions is not to criticise the recent developments or the changes, simply to point out that solicitors have had to adapt to those developments. It may be that solicitors will fade from small personal injury work completely because it might be all done by AI, but my point is simply that it needs to be adapted to what in 20, 30 years has been a completely changing legal landscape, and one that is very different to the practice of solicitors who might instruct me in my day job as a property lawyer.
But there are still an awful lot of solicitors who do specialise in personal injuries and specialise in small personal injury cases.
There are, at the minute, we see this. It's difficult to know because of the changes on have only just come in just over a year ago. There are no statistics as to how that I know of as to how that's affected the number of solicitors doing personal injury work.
Well, what we do know is that the number of cases going through the RTA portal has severely reduced from the 600,000 a year. Now, they reduced during COVID for different reasons. Then they reduced again because of the introduction of whiplash. The whiplash portal from May last year has now had more than 300,000 cases go through it. And those 300 cases didn't come out of the air. They would previously have gone through the RTA portal.
Yeah, absolutely. If I think the statistics are, Mr Dixon alludes to them, that vast majority of personal injuries are under 5,000 pounds, just like this one. And if the procedure has changed such that most of those are to go to the new.
But what I don't understand is what drives the 90% figure. So, in other words, why do 90% of claimants not do what the government, I think, intended them to do when they issued those legislation?
I don't know is the answer. I might suspect that they're worried about dealing with how much they're going to get. Damn it, they don't want to be hoodwinked by shortchanged, perhaps is a better phrase, by insurers, because they have absolutely no experience of what a whiplash or what a broken wrist or a broken leg is worth.
But I mean, the other thing that seems to be characterising those claims is the indication that they've got more than whiplash, so they have two kinds of injuries, so they can get more damages.
That one, they may genuinely have more.
No, of course, but I think the expectation when it was introduced was that so many people had whiplash that if you reduce the damages for whiplash, then you would reduce the damages generally recovered.
Well, I'm sure there was whiplash fraud going on, but it wouldn't be my
There's
part.
still provisions for that.
Yes, it wouldn't be my part on behalf of the Law Society to say that people who say they've got whiplash and other injuries are not being genuine about that and are deliberately gaming
I'm not
the system.
asking about that. What I'm asking about is the general picture. I'm trying to get a sense of how these cases are now conducted. I mean, the other thing I'm trying to get a general picture of is how many cases, whether Whiplash Portal has taken over really all the small claims for personal injury. So the RTA portal, which I believe is limited to cases under 25,000, isn't it? Has, whether that still, that cases still get started in that portal, but are they just the ones that have expectations of between 5 and 25?
I'm afraid I don't have that.
Okay,
There's nothing in Mr Dixon's statement apart from and I have no personal experience and no instructions. I attempt to get instructions as to up to date.
I just wanted an overview if there were one.
Just, my lord, while you're asking these questions before Mr Holland moves on, the point that you raised about cases about the overlap of damages between whiplash and non-whiplash, I am in a position to give you a little bit of information about that, which may or may not have come to your attention. I understand the designated civil judge at Liverpool has just transferred some appeals from the district judge to this court. So in the hope that this court will accept jurisdiction under the, is it 5223 procedure, and give some guidance as to the approach to assessing damages in what I think are called mixed claims.
Yes.
So I think that is en route to your lordship's desk if it hasn't landed already.
It's not quite landed, but
Right.
I know about it.
There it is. I should have guessed that and not said anything. Forgive me.
Well, I didn't know that, so I'm grateful for my own friend. While we're at it, Turner, you don't need it, Turner Palomo, because its point is dealt with by Ms Justice Butcher in the Devonshire's case, which is at tab 49, page 1276.
Sorry, I didn't catch that.
It's Devonshire's case, it's tab 49.
Yes. Oh, in the authority?
In the bundle.
Oh, yes. Mr Justice Butcher.
That's right. Tab 49, page 1276, at paragraph 24, and it's sidelined for you.
Should we just have a look at that?
Sorry?
Should we just have a quick look at that?
Yes, of course.
Oh, this is about Turner and Palomo.
Yes.
Yeah. Paragraph
24.
24.
24. Oh, yes.
I seem to recall it was a case where a client had failed to seek taxation or detailed assessment within time. The solicitor had applied for summary judgment and was refused on the basis that no, the solicitor still had to show that their fees were reasonable.
I haven't quite understood the jurisprudential basis for that. If you have a contract of retainer which says we will charge £150 an hour, and you have in fact spent 10 hours on the client's business, what's the ability of the court to say you can't have £1,500?
You better ask the Court of Appeal that.
You need to ask Lord Justice Evans that.
Yes.
I will get. It may be that the contract is said to be, well, 10 hours is 10 hours reasonable. So, but okay, you might not be able to challenge the hourly rate. You've agreed that, but is 10 hours a reasonable fee for what?
So it's just an overarching implied term,
Yes.
because of the nature of solicitors' business, that the court will look to see that they're not overcharging their clients.
Yes.
Yeah.
And that is even despite the fact that you've missed the statutory,
Yes.
specific statutory provisions in the 1974 Act, which entitle you to a statutory remedy of assessment.
Yes. And that doesn't depend on whether it's contentious or non-contentious business.
No.
That's a general principle
That's
applicable to all solicitors'
Yes,
fees.
that's right. And well, you heard me mutter under my breath about Herbert, but one of the points about that is that the Court of Appeal in that case said it was unusual for a solicitor to charge a success fee based not on the risk of the individual case, but rather, as the solicitors did in that case and in many other cases, based on this is what we need, this is the money we need to be able to run our book of cases. And I think the Society's problem with that is that's not unusual at all. And indeed, it's specifically mentioned in Callery and Gray, and indeed specifically encouraged by Lord Justice Jackson in his review. And that was our problem with that, because that's the way this is done. In order to make money, solicitors. Lord Justice Jackson
Sorry,
says.
can we start at the beginning with this? I think you're, if I may say so, you're making these submissions in the wrong order.
Yeah. Okay.
Where was it said that it was unusual to charge a success fee based on what the solicitors needed to run their
Herbert.
cases?
Herbert.
Whereabouts?
The Herbert.
Herbert.
Case. Yes,
Right. Could we see that?
Yes,
Yeah.
indeed.
This was my predecessor. He said this.
Yes, it was.
That's at tab 43.
Yes.
Which paragraph in Herbert did Sir Terence say?
paragraph 50. It's 1096.
The last sentence.
And it's 53 as well.
So which bit of 50?
It's 53. And that's the point on which the solicitor lost. It was said that because informed consent wasn't obtained to a success fee which was set not by reference to the risk in the individual case, but rather by reference to the book of cases, i.e. what was necessary for the solicitor in that case to make money by doing this type of case for this type of fee, then that was something which the client should have been informed of, and thereby there was no informed consent to that.
Well, it made it an unusual term.
It did. I think that the only point I make is that given...
You say it doesn't.
No, it's not an unusual term at all. And indeed, it's expressly contemplated by the Court of Appeal as long ago as Callery and Gray, and by Lord Justice Jackson, who says, well, if I remove the recoverability of success fees, solicitors can advertise on the basis that they charge.
You go so far as to say that Herbert is wrong on the facts.
Yes.
And you say, do you, that it was known to be a usual situation because of...
Well, it was expressly contemplated. I wasn't there. The society didn't intervene in that case. But it is a circumstance where you get I'll take you to the past, but Lord Justice Jackson says, well, if I remove the recoverability success fees, solicitors will be able to advertise on the basis they charge lower success fees than other solicitors. Now, they're not being encouraged to advertise on the basis that they're more gung-ho about the facts of an individual case. Clear implication is they're advertising because our business model is such that we are so efficient, we can charge you generally less than the firm down the road who are not as efficient as we are.
Okay, but you also mentioned a case that's...
Yes, that's Callery and Gray.
Callery and Gray.
Which is...
Can I just be sure, before we
Yeah.
put Herbert away,
Yeah.
that when you say that the Court of Appeal then said it was unusual, that word unusual is taken from the CPR. It's the one which says you can't recover on a solicitor-owned client assessment if it's an unusual charge and you haven't warned the client. So
Yes, but we said...
so it's not just a passing comment, it's actually part of the ratio.
Yes,
It's unusual in that sense.
Yes. I mean, I'm only pointing this out because this is the way the market is driven. This is the way solicitors are, because of the changes, because of the reduction in fees on individual cases, solicitors have to assess bulk provision of these services. And as I've already mentioned, you get paralegals to do it, you get lower grade fee earners to do a lot of the work, because otherwise it becomes completely uneconomic.
But when you say reduction of fees, there's not a statutory cap on what you can charge your client.
No.
It's the market which is driving the fees down.
Well, it's the CPR. It's the CPR and Jackson is driving the fees down, and they're set at that level. And yes, of course, and this is the point about Miller and Friends clients. They couldn't have charged the fees.
The 2,500.
2,500 because generally they'd get no clients because no one would come there because it's the market that's driving it down. You're right, because that's why solicitors are reducing their fees or are charging in the way that they're doing. And that's why, for example, as in the Herbert case, the solicitor said we generally charge 100%, but we cap it at a particular level there's a statutory cap on the success fee, and we impose a contractual cap so that our clients know how much they're going to be charged overall, the maximum they can be charged overall. And we can do that because we charge 100% success fee. We know what we're going to get in that respect. And my only... Well,
I don't get that. I'm sorry, say it again.
Well, that's sorry. It's the facts of the Herbert case. There's a statutory cap, as my lord knows, on the level of recoverable success fees, 25%
of base costs. 25% of damages for pain and suffering, but not for future loss.
That's right. That's right.
Pain and suffering and past pecuniary loss.
That's right. Yes.
Past pecuniary.
Yes.
But this is... I'm sorry, I'm obviously being very stupid, but I haven't quite understood what the economic difference is between a solicitor saying I'm going to charge you £2,500 and I can charge you 100% success fee, so that's £5,000. But in fact, I'm going to cap the success fee, and the solicitor simply doubling their charging rate and saying I'm going to charge you £5,000 in the first place. Well, what is? I mean, I understand when these things were recoverable from the other side, that it's important to identify whether it's base costs or whether it's success fee, because there's a difference in recoverability. But in this situation, if it settles before it exits the portal, you're not going to get anything from the other side except the £500. Why does it matter whether it's called a base costs or success fee?
It doesn't matter. I mean, as you said, what the client wants to know is how much am I going to have, how much of my damage is going to be deducted by the solicitor.
Yes, what am I going to be left with at the end of the day?
That's right. And if solicitors generally practiced on the basis that the client got nothing because we charged our full fees, they wouldn't get any clients. That's the point. It's the market. It's in a way, it's what Jackson envisaged, in that solicitors would reduce their fees or cap their fees in a way which made it realistic for them to be engaged by clients in small personal injury cases. Because if it got to the stage where solicitors were generally taking all or most of the client's damages, then they wouldn't get any work. And not only that, but they'd get reported to the Legal Services Ombudsman and maybe the SRA. But that's the point. It's Jackson at work. And my only point was that was the intention. The intention of all these reforms vis-à-vis solicitors. It was accepted after the Jackson reforms that it would be a reduction in solicitors' income. But solicitors were expected to adapt to that and generally have. My own point, that's why it's a side wind to attack Herbert, but my point was that one of the ways solicitors have done that, as they were expected to do, was to get the level of success fees, not by reference to the prospects of success in an individual case or indeed in an individual type of case, because they tend to be the same, but rather by reference to their overall book of cases and what we need to recover to be able to provide this service at this price to our book of clients. I may be tilting at a windmill that I need to tilt at, but
I'm tilting at a windmill. I'm speaking for myself, slightly concerned about the relevance.
Yes, it's not.
You seem to have been on a side windmill.
Yes, I have. I was making a point as to how it affected solicitors' behaviour, but it's not something this court probably.
We're not being asked to decide that
No.
any part of this is unusual.
No, you're not.
No.
I raised that simply as a background, and I'm sorry if I have distracted you and wasted your time. My learned friends already addressed you on contentious, non-contentious business dichotomy. We addressed that in paragraphs 58 to 76 of our submissions, and Mr Dixon addresses it in paragraphs 36 to 43 of his witness statement. And we say the clear distinction is widely recognised. It may not be wholly logical, but it's clearly recognised in authority, and we refer to the Bilkus case, we refer to Telka Talk, and now we refer to the Bott case, the recent case in the Supreme Court.
Well, you say it may not be logical, but in fact, if Mr Williams's nomenclature point is a good one, that if you rewrote contentious, non-contentious as court costs and non-court costs, perfectly logical.
Yes, provided you court was a court of law properly so called, and not tribunal or for example.
Yeah.
That may be said to be. Maybe
That's why upper tribunal costs are
That's right.
contentious.
That's right. So
costs
if
because it's a court of record.
that's right. That's exactly right. There's academic works. We cite Friston. There's the Society's own guidance in 2012. And there's the point that's actually made in Telka Talk, I think we repeated it, is that section 58.5 of the Courts and Legal Services Act 1990, which has been replaced several times, excludes from the ambit of conditional fee agreements, makes it not unlawful, non-contentious business agreements. But if there was the dichotomy, as my learned friends for the respondents would draw it, then that provision would be OTOs, because there could be no overlap. But that expressly recognises that there can be an overlap between a conditional fee agreement on the one hand, which can also be a non-contentious business agreement. It's, so far as the society is concerned, the dichotomy is a creature of the 1974 Act and should remain within its four corners. It serves a purpose within that Act, or the provisions of that Act, such as they remain, and that's where it should remain. And my Lord, I heard my Lord the Master of the Rolls comments about the Solicitors Act. I think the Society's view is, I'll take firm assumptions, but that it is rather venerable.
Is venerable good or bad?
It's probably bad-ish. I mean, it's one of those things that it's a bit like the 1954 Act and the landlord tenancy. It's solicitors have worked round it for decades and decades and decades, and it's
maybe in need of generational reconsideration.
You might think that I couldn't possibly comment, but yes, I suspect that if it was if it was
48 years since it was fully overhauled, whereas the previous Act was 17 years earlier, and the one before that was 25 years earlier, in a very different, less changing world.
Absolutely, so that's the point. The legislative and regulatory landscape has changed round. I mean, I think that the relevant provisions of the 74 Act, I think, certainly Section 74, are very similar to the 57 Act.
I mean, you may not be old enough to remember this, Mr. Holland, but the way solicitors did their business in 1974 was completely different to the way it is today.
Yes.
And therefore, perhaps looking at it again to see how solicitors bill for their work, what regulation is appropriate, what is the true distinction between business conducted in court and not conducted in court, transactional business, international business, etc., etc. It might be beneficial, might it not? I mean, you don't have to be coy about that.
No, I entirely accept that, and no doubt the society would have clear views, and the society would hope and expect to be fully involved in any overhaul. But yes, well, one only has to look at the number of statutes which have succeeded it. And for example, the Legal Services Ombudsman is a key thing which was never around in 1970.
When was the Legal Ombudsman introduced?
I'll take instructions. I think it was 2007. I think is the Legal Services Act 2007. That's the provisions.
Right.
I mean,
also, of course, the regulatory reform in 2007 was transformational. I mean, I was chairman of the bar in that year, and I was very much involved in the discussions concerning that legislation. And we've already discussed the SRA and the Bar Standards Board, which came out of that legislation, and the Legal Services Board. And all that has not been reflected in the Solicitors Act 1974.
No. That's quite, it's sort of the island it's just sat there. And it has been amended, though. I mean, if you look at section 74.3, I looked it up, so it's just it's a county court
Yeah, it was a county court.
That's simply, but
In the 1957 Act, it talks about a county court.
that's right. And the amendment was it's the county court. That's all it is.
But
But
that's because we introduced a
Yes.
single county
Yes.
court, but that's
Yeah.
really got nothing
But
to do with
It
any of this.
doesn't really take us very much further.
no, but I suppose the point, and it may relate to any submission that there should be an always speaking construction, is Parliament has amended, or the section has been amended. It's been tinkered with to bring it up to date, but Parliament has not seen fit to abolish it or radically amend it. It hasn't added tribunals to the ambit of it,
No.
which it could. And I remember one of the arguments in Telka Talk was, well, hold on, because it was then argued on behalf of HNRC that you should give it an always speaking interpretation because there's tribunal. But tribunals were around in 1957. They were certainly around in 1974, and Parliament decided not to specifically include them. But whatever reason, it's there in the 1974 Act and their provisions, and solicitors still comply with them and have to comply with them. But whether it's a more modern, particularly of costs assessment for clients, I mean, one might think that a more modern system which doesn't involve the issue of court proceedings would be much more, much better than that system which has survived for decades and decades and decades. And we agree with Mr. Williams that on the facts of this case it makes no difference either so far as the client is concerned, albeit technically there is a difference in how costs are assessed, but certainly given the concerns expressed by the Master of the Rolls in the last hearing, it makes no difference to the operation of the pre-action protocols one way or the other. We agree with Mr. Williams on 46.9.2. The wording's different. The wording is significantly different. The provisions have completely different origin, and one looks at the written agreement. That's what you're looking at. The other looks at approval. Now one can debate whether it's about approval. You can see how one could say that any approval has to be informed approval or informed consent. There's a much more amorphous concept than simply there being a written agreement which permits it. We would submit you're drawn there to look purely at the written agreement. And the standard contractual term is if you sign an agreement, you're deemed to be bound by it. The Law Society standard form of conditional fee agreement provides for signature, as does the one here, because it uses the form, and indeed explicitly states we will not be bound to act on the CFA unless both parties sign it. I think it's a strange growcob. You're deemed to sign understand what you sign, and that's what you're directed to by that provision and that particular provision. So we say there's absolutely no warrant for imposing the same kind of qualitative test under section CPR 46.9.2 as the court in Herbert did under 46.9.3. Can I then move to specific comments about these cases? And again, I'll skate very quickly because
So what do you mean by these cases?
well, this particular case. Well, there's Herbert and Cap, because they're all the solicitors acting for the clients in these cases are either the same or associated and have the same business.
You haven't intervened in SGI and legal.
No, we haven't. But the comment on this case, which happens to be the same as the other cases, first one is there's complete absence of evidence from the clients themselves. There's no evidence that the clients made any complaints directly with their solicitors who had acted successfully for them in this case and in the other cases. There's no evidence that they sought to use the solicitor's formal complaints procedure, and there has to be one. It's a prerequisite of using the legal service, the legal ombudsman, that you use a solicitor's complaints procedure, but the solicitor, by under the SRA guidance, has to have one. And there's no evidence that from the clients that they ever sought to use the legal ombudsman to resolve the complaints that they had. And when one's dealing with, I suppose, perhaps the Consumer Rights Act point, there's no evidence from the client here that what she would have done had the contractual documents contained the passages which my learned friends of the respondents say ought to have been contained in the documents. I say that point again goes to the Consumer Rights Act point. As I understand it, consumer rights cases all depend on individual circumstances, and it's very difficult to see how such a case can get off the ground now in this court when there's no evidence from Ms Belsner as to what happened, what she said, what she thought, and what she would have done had she been had certain things happened and certain things not happened. The next point the society would make is one I think the court has, is the costs spent and the court time incurred litigating over comparatively small amounts of money. And even if one ignores the appeals in this case and in Herbert and in SGI and just deals with the first instance, that is, that what would have happened but for the appeals. This, I think, my learned friend, Mr. Williams, I think this is the case. This case is over £385.50, and the costs awarded to the respondent solicitors were £3,484, and that's not including the costs which were expended by the appellants in getting there. And just at first instance, if one looks, the claim form was issued on the 4th of July 1918. Directions were given, this is for the assessment, on the 21st of January 19. There was a provisional assessment by the district judge on the 9th of February 2019. There was an assessment hearing on the 2nd of July 2019, and there were written submissions on costs on the 7th of August 2019. It's 2 assessments, 1 hearing, and over a year. All over £385.50. And that's ignoring the appeals.
But I mean, what's the point? Well, I mean, they're entitled to bring the claim. They're entitled to bring the claim.
Well,
or is your point that there should be special circumstances and they should never ever get their costs of bringing such a claim, even if they win?
Well, I would go as far as the second that point. Yes, quite frankly, I think this court.
But I mean, just saying it's ridiculous doesn't get you anywhere.
Yes, it's ridiculous in this context where you've got a perfectly reasonable, swift, and readily accessible means of addressing the grievances in the legal ombudsman.
So that all goes to the...
That's all well and good, but the reality is that they can use this procedure. Now, whether as a consequence of using it and racking up all their costs, they should be entitled to recover them is a completely different issue. But we have to decide the point of principle on the basis that they have brought the proceedings in the High Court and they're entitled to bring this proceedings in the High Court.
Yes.
So making the point that it's
not a
totally ridiculous.
It's not a jurisdictional point.
No,
it may be a point which persuades you that if
it sounds more like a jury point.
It's a jury point.
Well, it's a jury point only in the context of the next point, which is the legal ombudsman is there to resolve this type of dispute.
Well, it's section 7010 point.
Yes, and also it's it's probably lawful, but it's the business model of checkmylegalfees.com.
Yeah.
Well, that's a different question, but there is a sense in which it's important that solicitors are subject to regulation in court, and it is a right of a client to say, I want a judge to look at this.
It's a statutory right of a client. I accept that, but in no other sphere would you get, if I came to the High Court and said, well, I want you to, I've got a battle over £385,
No, but this is why I was so surprised how coy you were in answer to my question that the Solicitors Act needed changing, because one approach to the Solicitors Act is that the idea that you can assess costs of this kind in the High Court is ridiculous.
Yes, well, I think the society would agree with you.
Yeah, well, so...
maybe if I appeared coy, then I'm sorry. Maybe I was...
I think you thought you would be overreaching your instructions. But the point you're making here is, as it seems to me, twofold. One, this is disproportionate. Two, it's relevant if you consider the respondent's notice in SGI legal, which you're not dealing with under 4010. And three, maybe the legislation does need looking at, which is something judges can always say. Whether governments listen to what judges say is always another question.
This court is entitled to say of course there's a statutory jurisdiction under the Solicitors Act but it should be used appropriately. And if a client has a genuine grievance about the amount they've been charged by their solicitor or the way the solicitors behave, there is a properly cheap and easy way of doing it through the legal ombudsman. And if you bring a case such as this where you're arguing over,
you may not get the costs.
You may not get the costs.
That's different.
And it seems clear to the society that the reason there is such a volume of claims, or these claims are brought, is because someone has had the clever wheeze of having a business model which depends upon it, and depends upon not only Section 70 of the Solicitors Act, but upon the funding method they've got, which is, again, perfectly lawful, of no win, no fee, CFA light, funding the disbursements and indemnifying them against adverse costs.
Can you tell me what a CFA light is? I'm afraid I don't.
Sorry, it's one whereby you only charge what you get from the other side.
What they can do is their costs aren't fixed.
Yeah.
Right.
It's a specific amendment which allows breach of the indemnity principle in that regard. I think it's virtually
under what provision?
Oh, I'll get you. It's section. It'll be under section 58 of the Courts and Legal Services Act as amended. But it's absolutely standard. It's been I think it's the most common form of conditional fee agreement in personal injury cases.
What? In non-fixed cost cases.
In non-fixed cost
they
cases.
don't work in fixed cost
Yeah,
cases.
they don't. Sorry, you're right. They don't work in non-fixed cost cases. Yes.
Yeah.
So effectively, Ms Belsner has a free ride here. Fair enough, it's very lawful, but she has got no skin in the game. If she gets money back, she gets money back. If she doesn't get any money back, she doesn't have to pay anything. Now, it's perfectly lawful, but again, it's not very proportionate. If, as we identify, there are three trends in modern litigation. One is to discourage people from going to court at all. Secondly is to discourage the spending of disproportionate costs, or costs that are disproportionate to the issues. And thirdly is satellite litigation over costs. As we say in our skeleton, the business model of checkmylegalfees.com appears to cut across all three of those particular principles.
But CFA light would mean that if this court said that they couldn't recover their costs, they couldn't recover them from her either.
No, that's right.
So they'd be left out of pocket.
Yes. But that's the bet they take.
Yeah.
Who is at risk as to the cost of the appeal if we allow the appeal?
I've no idea.
No.
It's not. We're not charging our costs win, lose or draw, but
No,
I
no.
Mr Kirby will tell you.
We know in other cases.
Do you-
You said it yourself.
Oh yeah, well the Ms Belsner is indemnified by the solicitors.
Against all adverse cost orders,
Yes.
including adverse cost orders.
Yes, we think. We don't know,
Yes.
but that's certainly in another case, Slater Gordon, that's one. And that's my fault. That's on the law side. So that's Sibthorpe and Southwark says that's a lawful thing to do. UCAM solicitors indemnify their clients against adverse costs, or it's not Champertus, and this court has held that that's lawful. But the effect of all
Well, it plainly is Champertus. It's the solicitors who have an interest in litigation, not the client.
Lord Newberger said it wasn't.
but it's not unlawful.
It's not unlawful, Champerty.
Yes. Oh, well, sorry. Yes, it's not. Sorry, if one takes Champerty as unlawful, then it's not unlawful.
No, but it is in fact. If what you've described is correct, then the client has no interest in the outcome of the litigation, win or lose, apart from the
£385.
yes, the amount that's actually at stake, but no risk,
No.
one way or the other.
No.
And the solicitors do have a very significant risk.
Well, the solicitors would say they know the solicitors on the other side. As I understand the evidence, is that it's been held in a previous case that in cases like this, the client, through their new solicitor, is not entitled to the retainer documentation of the original solicitor until a claim is issued for its assessment. And therefore, they're running blind in a way. I think, is that right, Ben? Well, I'm sorry.
There may be cases, but that doesn't.
I think that it's said, hold on.
Yeah.
Well, I mean, all this is slightly off the point.
Yes.
It's
Yes.
miscolored. Anyway, but that's the point I'm making, and is that this standing back, the society would submit that this is disproportionate, and in any other sort of claim, this would be condemned as disproportionate. Now, that being said, the society would never be heard to say that solicitors should not carefully and fully comply with their duties under the SRA code and explain the costs, liabilities and the costs benefit to their client. Society does not say that, and indeed, as my learned friend has pointed out, it's an express term in the Law Society standard form of CFA that the solicitors are obliged to do that. The society would never be heard to say that clients should not be able to raise bona fide concerns or challenges to their solicitor's costs.
When you say explain, are you saying that the solicitors have to give an oral explanation of the meaning of the 47 pages of documents they send to their client?
No. A lot is contextual, but that's the problem with this type of litigation, in the sense that because of the regulatory overlay and various legal principles, solicitors feel constrained to send, I think it's 47 pages of, I don't think that's in any way unusual, because you've got the CFA, you've got the Law Society conditions, you've got, it's not unusual for solicitors to send an extra explanation as to the way PI claims work, along with the letter.
Well, I mean, let's get this clear, because I think this is quite important. The solicitors send a 7-page letter, which no doubt is not untypical. It may be 3 pages in some cases and 7 pages and 10 in others. And at every page, the solicitor says, you must read the CFA carefully, you must read the terms and conditions carefully, something that they well know no client ever does. Right? Now, are you saying that it is a breach of the code of conduct, a failure of the duty of the solicitor for any other reason, if the solicitor simply sends such a letter, obviously in the appropriate terms, and assumes that the client has read it when they sign the CFA?
No. I think this letter says, as most would, that if you have any questions, please contact us. But you can't. It would be very difficult indeed with this type of litigation being conducted in this way to have a telephone call, let alone a face-to-face meeting.
Well, in the real world, people don't, though, do they? I mean, I don't suppose Ms Belsner read any of this.
I've absolutely no.
Signed it.
I have no idea, but
No, I know we have no idea because we have no evidence from her, and I follow that point.
But the alternative is, I mean, one got in the tag case, which my friend Mr Williams was involved in. There was a regulations that you had to go round and explain to the client. So there was so people were sent round to people's houses to sit down and read them out a crib sheet, and the terms of the crib sheet were challenged as being. But it's unrealistic, I'm afraid, given the fees that are allowable and what is realistically going to be charged, to expect a solicitor to ring up every client and take them through what is, I accept, complicated or potentially complicated documents. The Law Society's CFA is as clear as we can make it but of necessity, given the regulatory overload and the way this will work, that it's going to be, certain clients are not going to understand it.
But this is very significant, isn't it? Because what is said against you, everything that is said against you is really on the premise that the solicitor does owe a duty. I mean, I can't remember the paragraph numbers now, but the paragraph 9.6 and 9.7 or whatever it is of the code, and we can look at it, says solicitors must explain, fully explain. I mean, let's just look at it. It's worth it.
It's 8.6 of the
Sorry,
code.
8.6.
And where do we find it?
So,
It's in your skeleton, Mr. Holland, I think.
Yes, but it's at...
well, you must ensure that clients receive, this is 8.7, must ensure that clients receive the best possible information about how their matter will be priced, and both at the time of engagement and when appropriate, about the likely overall cost of the matter and any costs incurred. So must ensure receive the best possible information about how their matter will be priced, and provides they should give clients information in a way they can understand and ensure they are in a position to make informed decisions about the services they need and the options available.
Yeah.
Right. Okay. Those 8.6, 8.7. Now, you are not saying that it is a breach of that provision to send a 47-page, very complicated mass of information, but you would say it's compliant.
Yes, my lord, I would. I mean, it's not said against me, for example, or rather, it's nothing said against me, but it's not said that in this case the solicitor should have rung up Ms Belsner and checked that she'd read everything and offered or proffered an explanation.
What is said is, the solicitors said it was going to cost £2,500 to get to a particular stage. They said that you can recover all or part of it from the other side. They didn't say, if it settles when we expect it to settle, the most you can get from the other side is 500. So we reserve the right, though actually we're not going to do it, to take the whole of your damages in cost.
Well,
that's what's
well, it's
said
not.
against you.
What's said, there's certain passages are said. It's in Miller and Friend's skeleton. It's not. It said we should have proffered some sort of explanation as to the recoverable costs under the.
Should have said you'll only get 500 from the other side. That's what's said against you.
Yes,
Well, that's the point.
but that's Miller and Friend's
Even though we could charge you £2,500
Yeah.
if we wanted to, you'll only ever recover 500 from the other side, and therefore, although the chances of our ever doing it are very slight, because of all sorts of economic reasons or regulatory reasons, whatever it might be, you are actually at risk for £2,000. Therefore, your whole damages could just disappear
Yes.
down the drain.
In an ideal world, the solicitor ought to have either, as they did in Herbert, insert a specific cap, and indeed the Law Society CFA previously provided for a cap, or ought to perhaps have put a warning in that if they weren't going to impose a cap, that there is a risk that your damages will be substantially reduced by the excess costs which are irrecovered from the other side.
Well, that's in a sense where the real mischief lies, isn't it? Because that's the point that my Lord Master of the Rolls put to Mr. Williams earlier, which is that the real mischief here is going around saying you could be on the line for £2,500 when the reality is they were only ever going to charge a fraction of that, as opposed to saying we will only ever charge you X plus Y.
Well,
And if that means that there are cases in their business model where it all goes horribly wrong for the solicitors because the case ends up more complicated than they thought, well, that's a risk they take. But in terms of complying with their regulatory obligations, they wouldn't be in trouble.
but it would have been better if there had been that. If they genuinely had, I mean, it may be. One doesn't know that they didn't put it in because they had this practice that they didn't. We're not going to. We're going to cap our recoverable
I
costs.
mean, one of the most misleading parts about this agreement is the first line that says this is no win, no fee.
Yeah,
Well, that sort of means if you win, you pay a fee and you get something, not if you win, you pay a fee and you still get nothing.
Well, I'm not here to defend this particular individual.
Well, I know, but you see, the problem with the history is that the reason why it's called no win, no fee is because of the way it used to be done under original conditional fee agreements, which have all been completely messed around and changed by the successive developments that you and Mr. Williams have told us about and we know about. But actually, it's not a very good phrase anymore.
Well, it's no win. If you don't win, as is defined in the agreement, you don't owe your solicitor any fees.
No, but if you do win, you may still get nothing, which is not exactly what it implies.
I'm not sure. Well, it
Under
is
this
technically
agreement, that's the case.
Well,
I mean, under this agreement, the vice in this agreement, you know it and I know it, the vice in this agreement is that if it had been given effect to, then she would have got nothing.
And in fact would owe the solicitors money.
yes.
yeah.
That is a terrible vice, right?
And it doesn't seem a very attractive way of doing business to tell people we can charge you £2,500 when you have no intention of charging people £2,500. It just seems a very odd way of doing it.
It's a very odd way of business. If you wouldn't boast about it, you wouldn't put it in. But yes, I accept that. But
Unless you put it in because you are covering your, hedging your bets, putting it bluntly.
But there are
There
cases
might
where
be-
you
there
do
might be-
want to rely on it.
Precisely, there might be circumstances in which you would rely on it, and you would enforce the 2,500 against the 1,700 damages. Otherwise, why do you say it? It just makes no sense. One of the things that's puzzled me about this case from the very beginning.
well,
It just seems a very odd way to carry on.
I'm trying to meet. I'm trying to defend Mr. Williams's client's
Well,
agreement.
well, I understand it's not your
The
contract.
point I'm trying to make is where we started on this was the Master of the Rolls asking me whether this was a breach of the.
The best possible information.
Yes.
Well, it's quite difficult to say that she did get the best possible information.
Well, it may be, but that's well, no doubt. Then Ms Belsner will report them to the I suppose you might say all the more reason why she didn't raise a complaint against them.
Well, as you've told us, maybe she's not bothered, particularly one way or the other.
She's not bothered because, in fact, she as Mr Williams has pointed out, they did impose a cap.
Yeah.
And so far as solicitors complained, until she instructed checkmylegalfees.com, she had no complaint. But there's nothing wrong, in my submission, with a solicitor seeking to comply with their regulatory obligations by sending documentation to the client, albeit if they then say, please read this carefully. If you've got any problems, please ring us up and ask us.
I mean, the reason I'm asking these questions is not because I want to descend into the question of whether or not the solicitors have breached the code, but I want to find out, for the benefit of everybody who solicitors who undertake this work and clients who are likely to instruct solicitors to do it, whether it is or is not lawful and appropriate for solicitors to proceed as these solicitors did by sending 47 pages of material without any oral explanation to the client, or are we going to be back in court, whatever we say in our judgments in this case, when somebody says that simply is unfair, inappropriate, breach of fiduciary duty, whatever. I think we do need to face that question. It's all very well to sort of, for you, Mr. Holland, to say, well, the Law Society thinks it's okay, and then you, if I can put it this way, cross your fingers behind your back and say, well, I hope that submission went down okay, because I did it with a straight face. But actually, in justice, because that's what we're about in this court, it does seem odd that it is okay just to send off a raft of impenetrable documentation to a person who's got a claim for a very small matter, having fallen off the back of a motorcycle, whose only interest is in seeing if they can get a bit of compensation, when actually what they need to know, as my Lord Justice Nugee has said so often in this case, is three things. What's going to happen if I win? What's going to happen when I lose? And is it going to cost me anything? And how much am I going to get?
The problem with that is we have a raft of regulations and statutory, and there's all this encrusted law that, let me do it this way, it was wholly unrealistic given the way, which I've sort of explained, Mr Dixon has explained, the way the personal injury market is
I think we all
to
follow
expect
that.
face-to-face meetings.
I think we all follow that, but the
No.
point my Lord's putting to you is whether it's unrealistic or not, we have to decide whether or not it is just and appropriate, so whether or not, because it shouldn't be happening, practices should change, and if it means that the current way of doing things or the way that things were done in 2016 is unrealistic, well, so be it.
But you have to give information to your client. In the state of the current PI market, or in many cases, that you have to do it in writing, at least initially, and attempt to be as full as possible in writing. The Law Society's CFA, before it was withdrawn, was tried to comply.
How many pages is it?
I don't know, it's about 20.
20 pages.
Well, let me have a look. It's in the. It's in.
I mean, this may be a bigger question than just this case, as to consumer contracts generally.
If you go to 390, it's supplemental 2. It's 390 to 411.
Well, that's a very good estimate, 20 pages.
21.
22.
22.
I mean, I sort of had a hand in drafting a very small part of it, but it's very, very difficult to do it and try and do it in a manner that is comprehensible and yet tick all the regulatory and statutory boxes.
The difficulty is that giving people more information
Exactly.
doesn't necessarily make things clearer.
No, but suppose I set out in a letter, right, here's the 40 pages of document, here's the summary.
You
With
then
your
get
information.
criticised if a summary is not comprehensive.
Exactly, and that's exactly what happened. It's exactly the comment of this court in Hollands and Russell. And it's exactly what happened when we learned from Mr Kirby's submissions, most of which were rejected in the Herbert case.
Is Hollins and Russell a case that's in the bundle? Or
Twice about.
Yeah. Yes,
Yeah.
yes it is.
If I can
It's
take an analogy from a different field, members of occupational pension schemes, pension trust deeds are now 150 pages long, and even professionals can't read them and understand them. But the trustees do in practice produce little members' booklets which are written in plain English and meant to be accessible. They all say these don't override the rules, and if there's any conflict, it's the rules which actually apply. But they are intended to give ordinary members of schemes at least a first point of reference to what they're going to get out of their pension scheme. And isn't it possible to do something?
well, the society would say that if you sat down and read its CFA, it is comprehensible in those terms because it's intended to be read by members of the public who are lay people. And if you read meaning of win, meaning of lose, it's I say that because I only drafted 0.1% of it, or one particular clause in it, but it's comprehensible in that way. But then you've got an explanation, and I suppose the solicitors here would say, well, we have a guide to personal injury litigation, which we've enclosed, and if that was you sat down and read that, then it would explain what is happening, because the CFA doesn't explain the process of personal injury litigation. And then there are all the things you have to set out in your letter of retainer. You have to explain what your charging structure is if it's not explained in the CFA. And then there's the Consumer Rights Act, the consumer legislation to comply with. And it all adds up. And it may be unrealistic to expect lay people who just want to get on with the damages claim to read it.
Well, it goes back to my law's point, which is that what the client wants to know is the bottom line. How much is it going to cost me? And how much am I going to recover?
Well, it may be if this court says that whatever else you send to the client, there ought to be a one-page or half-page summary. Then solicitors will do that. Provided.
I mean, it's a different issue as to where any of it goes.
Well,
both you and Mr. Williams say, well, even if this court were to say that, then it doesn't mean that we should dismiss the appeal because the judge got it wrong for all the reasons Mr. Williams has given us.
No, I'm not concerned about the outcome of the appeal in that way. And the master of the rolls is the master of the rolls, still has a role in respect of solicitors. And if this court's, we're all here, if this court says that we're appalled by the level, the volume and complexity of the documentation was sent to the client in this case, really there ought to be some form of easy explanation which either cross-references or says, well, look, this summarises, this is what you want to know. Please read this carefully. This summary is our attempt to summarise what we are going to agree. But if you want to know in detail, A, please read the documents, and B, if you've any problems, please give us a call. If this court says that, then no doubt solicitors will attempt to comply. But the fear is that A, you're just adding, it's information overload, you're adding to it, and you're giving another stick to B. I see that sentence there, it didn't actually comply with page 47 of the document. See, it's a miss, because that's exactly what happened in the Herbert case. A whole lot of unmeritorious points were raised about it, and they were rightly dismissed, but it got to the Court of Appeal before they were dismissed.
And also there's a danger if you say, in our experience, most cases settle in the portal at stage 2, and in those circumstances you'll pay £500 and you'll recover £500 in costs, and etc., etc. A client whose case doesn't then settle is then going to say, oh, I thought it was going to settle at that stage. And
that's right. The 2 points to make. One, most cases don't settle in the stage 2 of the portal. I think the statistics show that that's not right.
No, but they do settle very soon, though.
Oh, yes. Oh, absolutely. Most cases, it's right to say most cases settle, but it's not right to say most cases statistically right to say. It's page 282 of the...
Anyway, stage 2 of the portal is no longer relevant.
There are portal statistics in there, but they don't.
Yeah.
But yes, absolutely, most cases settle. But we set out, I think it's paragraphs 42 and 43 of our skeleton. We set out the number of different stages, number of different... So I accept you can say most cases settle without the need to issue proceedings. There is a portal procedure which does that, and there are fixed costs. It's difficult to predict at which stage cases might settle, but these are the costs. But again, you're giving more information. So if you want to be fair and accurate, if you want to be accurate, you've got to set out a whole load of different scenarios and a whole load of different costs, outcomes, which are possible. And if you, and as I said, I take just Nugee's point, it might be easy to say, well, look, most cases settle at this stage, these are the likely costs.
Well,
but
you
if they
could
don't,
say, couldn't you? Why couldn't you say, well, look, this is what happens in the majority of cases, whatever it is, this is what the consequences will be. If you want more information, or if you want to discuss this further, then telephone us and we can talk it through.
that's right, but I think...
If you're concerned that your case might be different and that something else might happen, that's something we can discuss with you, rather than producing some completely incomprehensible table 5 miles long, giving you every conceivable permutation. And that seemed to me, I follow the point, and I follow that in a sense, on behalf of the Law Society, you're taking a sort of defensive stand, if I can put it that way. And I don't mean that offensive
No.
at all. But it did seem to me that the whole idea of this sort of long screed that it would be produced was a slightly sort of defensive approach. When you could do it in a kind of realistic and sensible
You
way.
could probably do it in a page, but it'd be a page.
Yeah.
You know, these are the most cases settle before the issue of proceedings. Now, but it's difficult to say what. So there are a number of stages at which you might settle, and these are the costs outcomes of it.
Yeah.
But that's at least a table with 4 or 5 different entries in it. And I accept an educated layperson would read that and understand it. But it's more information, and whether that would conform to the brief summary as posited by Lord Justice Nugee, one doesn't know.
You see, what I find difficult is that the court, it's really a very difficult job for the court to be prescriptive about what should happen in the future. We can say whether this case, in this case, there was a breach as alleged or not. We can say that we think things went wrong because there was no information as to the possibility of, indeed the likelihood, of recovering fixed costs at a small figure, which would be less than the main costs, than the charges. But whether we can really say what should have been done, or whether 47 pages is intelligible to a normal client. And the difficulty is that we've no idea about Ms Belsner. She may be a highly intelligent lawyer for all we know.
The only thing I've been able to find out is if you tap Daria Bellsner into Google with inverted commas, you come up with a
She might be watching.
a LinkedIn page, the top of which is a photograph that looks very like the photograph that we have of her from the Daily Mail article. And this Daria Bellsner has a Human Resource Management BSc from the University of Bradford and an MSc in Human Resource Management from the University of Bradford, and is currently the Senior Director Custos Mort at EMA. I think that she's more...
Well, I mean, we
anyway,
weren't going to assume anything about
Well,
her. But the,
perhaps Mr. Kirby could tell us.
but
She's
the
his
point,
client.
but the point I'm making is that we can't dictate what should happen in every case. We haven't had enough argument to do that. We don't want to. When I was tweaking your tale about the submission that it was perfectly okay to present 47 pages and say that's fine, what I was trying to establish was whether that is something that the Law Society said could comply, provided the 47 pages were obviously not gobbledygook and were could comply with the obligation to give the best possible information. And I think you're saying, and I think your submission has certainly some arguable merit. Yes, we're not nannies. Solicitors are not nannies. They are entitled to send properly drafted information containing the things the client needs to know without ringing up and saying, did you read page 2 and did you read page 3? It might be desirable, I think you might also say, to have a helpful summary at the beginning or a helpful 7-page letter at the beginning. But all this can be done lawfully, and you would expect it to be done lawfully because you say, Lestrange and Graukob says if you sign things, you're bound by them. Now, that submission, it seems to me, can be made with a straight face and is relevant to what we have to decide. Because if you were saying, no, it would be better if there were a phone call, it would be better if there were an explanation, you can't get fully informed consent without ringing them up and saying, do you really get it that we're going to charge you this or that, then that would go a long way towards what Mr. Kirby is saying in relation to his fiduciary duty. And that's why I have been exploring all this with you. I don't think we can actually, in our judgment, say you must do this or you must do that. We can say it's desirable, you must comply with the code of conduct, of course, all those things. But I think we have to be quite careful, particularly in a case where there are hundreds and thousands of these cases, not either to make the solicitors' lives impossible about undertaking this business, or indeed the clients' lives impossible, because they are probably, I think as you indicated, don't want the old-fashioned system where if you wanted a solicitor you had to go along the high street, find one, make an appointment and go and see them in person. People simply don't want to do that.
And also, am I got this wrong? I think it's picked up somewhere that the business model, as it were, has changed since, in other words, these firms don't use this approach anymore. So this is, as it were, a legacy case, even though there are quite a lot of these cases.
I can't say.
By which I mean that now people actually say in terms, well, you know, the most we will charge is X because there's a cap.
I can't say that as a matter of Miller. I don't know whether Miller for Mr Williams say that. I'm not sure. I don't have the statistics for
Well,
the position is different now anyway, because this claim would go within the whiplash portal, which is quite different.
or may go.
Well, apart from parts on the motorbike.
Apart from the motor- Well, the motorbike point only means it's a vulnerable user.
Yes.
It means you might get some costs.
I'm afraid at the minute I don't have any instructions as to what solicitors generally do.
Right, okay.
But I don't imagine that things have changed, that we're now back to the face-to-face meetings.
No.
on the
No,
side.
no, I don't think
But
that's
it's the society's view that there's nothing that's a breach of the regulations to send information in writing, whether by email or in hard copy, provided what is sent is clear.
I mean, what we can say, and what no doubt the Law Society would say, which is very difficult to comply with, I understand, is that information should be kept totally up to date and be totally accurate and be summarised.
Yes.
Now, unfortunately, that's an aspiration that is not always going to be complied with, but it should be.
Yes. Well, all right.
And it should be concise.
As concise as...
I actually don't believe that 22 pages is concise, but, you know, it's call me eccentric if you like.
Well, no doubt the society's CFA, which was widely used and it still was used as the model for this, is now formally withdrawn the website, awaiting the outcome of these and other cases.
Well, your point which you made earlier, in the sense of a partial answer to my lord's point, is that there were a lot of things that the CFA had to say by virtue of the regulations, by virtue of the code of conduct and so forth. And the difficulty is if there are a whole load of things it has to say, not just about what we're focusing on, but lots of other things, then maybe you can't do it in less than 22 pages. And it did get some prize for being in
well, as Lord Justice Brooke records in, I think it's Hollands and Russell, it received a plain English award for being the crystal mark for being put in.
In 2003.
Yes, hasn't changed much since then. There's been it's been added to. For example, it was added to when the new cap on damages came in. We had to insert a passage about capping the damages when Jackson said we had to cap the damages, and it was felt, given the consequences of not that simply just setting out the words of the statute was the only thing to do in that, due to the risks that might arise if someone said you didn't accurately. Because bear in mind, these are being used thousands, if not hundreds of thousands of times a year, and if there's a fault in this, okay, the Law Society puts it forward simply as a draft, but solicitors will tend to be conservative given the number of attacks that there have been in the past on the enforceability of CFAs. Solicitors tend to be cautious. But no doubt, my lord, I will say that any comments made by this court will be closely and carefully examined by the society and guidance given accordingly.
Yes. I mean, the difficulty is having sufficient factual base to give useful guidance.
Yes. I
mean, we can say what's wrong, but it's very much more difficult to say what's right.
well, we'd rather you say what's wrong than say nothing and think it's wrong.
We'll have to say something, won't we, Mr. Holland?
Yes, I suspect you will do. But no, well, I speak for the society. We would like to hear if
I'm not guaranteeing you'll get 22 pages.
Oh, what's wrong?
Well, maybe that's because my lord will be able to say it much more concisely. My lord, I note the time. I've just a little more. I don't know whether you want to.
Yes, you carry on, because we said we'd sit till 4:30.
Okay.
And if we can finish tomorrow, we'll be delighted.
Okay, in which case
I'm not putting you under pressure.
I mentioned the terms of the code. We then mentioned there's a number of protections available to the client. I think Mr. Williams has already, even if you allow this appeal, there's a number of protections the client has. There's 46.93, which would still apply. There's the indemnity provisions in the detailed assessment. Has to be reasonably incurred and reasonable in amount. And as Mr. Williams points out, the district judge has already come to a view as to what is reasonable, which is more than has been charged. There's the Master Cigars case, and indeed the obligations are set out specifically in the Law Society Standard CFA and in this one. We set out the Ombudsman scheme at some length, and we commend that to clients. As I said, it's not the case that the Law Society would ever say solicitors should escape scrutiny of their bills, but there is a way of doing it set up specifically under the Legal Services Act. That is initially the Solicitors' Complaints Service, which has to be, as do members of the bar now, have to have an in-house complaint service or procedure, and then the Legal Service Ombudsman. And we set out the provisions in paragraphs 22 to 27 of our skeleton, and we set out the relevant provisions. Now, what has to be the Ombudsman is looking at what is fair and reasonable in all the circumstances. That's the statutory test. It's repeated in the rules, and the rules emphasise that whereas the Ombudsman will look at or consider what a court would do in similar circumstances, they're not bound to do what a court would do. So they're not bound by any legal rules at all in that way. Any determination is binding at the suit of the client. So Legal Service Ombudsman Legal Ombudsman says, this is my determination. If the client says no, I'm not satisfied, I'm going elsewhere, it's not binding. If the client says yes, it's binding on the client and the solicitor. No costs involved, there's no charge to clients, and any award is enforceable by the court.
But there's no delay, is there, in the time limit for assessment? If you go to the Ombudsman?
I'll look up, and I don't know whether there's a time limit on. I think it's generally 6 months, but I'll look up that it'll be set out in the rules. But it's not as strict as, for example, the time limit on Section 70 challenges. There are very strict time limits on that.
No, but that's what I mean. If you go to the Ombudsman, won't you let the time? Because you're not obliged to accept the Ombudsman's decision.
If there's any time limit issue, you can. The Ombudsman won't act if there are ongoing legal proceedings.
No, that's the whole point.
But they can.
So
You can stay.
What you can't do is issue a request for an assessment out of an abundance of caution, and then go to the Ombudsman, see if you like the outcome, and if you don't, go and do the assessment.
You can if you stay the assessment. If you say, I'm issuing this assessment, if you said to a court, I'm issuing this assessment out of...
But then the Ombudsman would say, I'm not doing it because there are outstanding legal proceedings.
No, if it stayed. I think there's a provision in the scheme rules. Yes.
Could you just check that for me?
Yes, I will.
Because one of the things that I would expect Mr Kirby to say is this is all very well, but it doesn't work for that reason.
Let me find the scheme rules, if I may.
That you can do overnight.
Okay, well, I'll do that. Can I? We
Oh, here it is, David.
Yeah.
Um,
5.7, is it?
unless the proceedings at this stage
Yes.
are given full time.
It's rule 5.7. I'll point that out tomorrow morning if I may. We point to the case of NGO4 and the legal ombudsman as how this would work when it comes to costs. But also, if you go to the far end of the authorities bundle, the materials bundle at divider 48, you'll see there's the second edition of the Legal Ombudsman's View of Good Cost Service.
Sorry, what's that?
It's a document produced by the Legal Ombudsman entitled An Ombudsman's View of Good Cost Service, second edition. And it's my divider 48 of the statutory materials.
Okay.
And it sets out guidance. I think it's aimed at solicitors as much as anything else, but it sets out guidance, and it also sets out case studies as to where the Ombudsman has intervened and why they have intervened.
Yeah.
And there are cases there in which clients in litigious matters have complained and obtained redress, and they're set out. So it is quite clear that the legal ombudsman is quite happy, content to deal with costs disputes, not only in relation to the amount of costs, but also in relation to costs information. And I'm not going to take you through those, but I would urge you, if you have any time, to read through it, because it's an example. It's examples of why the legal ombudsman.
Well, it seems to support my Lord's point, because one of the first things it says is clients want to know how much it's going to cost.
Dealing with.
This is dated April.
Page
19.
7, page 450 in the electronic bundle.
Yeah.
Consumers will almost always want to know what the total cost of their case is likely to be.
Yes.
Right.
The previous point, it's divider 14, page 151, 5.7F.
It's cited in your skeleton argument, unless I misremembered.
It is. An ombudsman may, but does not have to, dismiss or discontinue all or any part of a complaint if, in his or her opinion, F, a comparable independent complaints or cost assessment scheme or a court is dealing with the same issue, unless those proceedings are first stayed by agreement of all parties or by the court order.
Sorry, which paragraph?
It's
5.7.
paragraph 5.7F.
Right. Right. So they can issue, stay.
Yes. And if they're not satisfied, they can say, I'm not bound by this, I want my day in court.
Yeah. Thank you.
Can just towards the end, I reserve the right to, if I deal with sweep up tomorrow morning, but I think given the focus that the court have had on fiduciary duties, I'll set out what we say on fiduciary duties, if that's all right. I make a number of points. In essence, I agree with Mr Williams has said. The relationship between a solicitor and the client gives rise to fiduciary duties. And we cite a number of cases where that is quite clear. Secondly, however, a solicitor is different from a trustee, properly so called, and the nature of the fiduciary duties owed by each is different. For example, a client fully expects to pay for the services of a solicitor, whereas, as my Lord Justice Lavender points out, the general rule is a trustee is not expected to be paid unless there is express agreement otherwise. But thirdly, it's always necessary, as Lord Justice Millett indicated in the Mothdew case, it's always necessary to ask or to analyse what the ambit and the nature of the various fiduciary duties imposed in the circumstances are. And I think that's the point that's made by Lady Arden in the Children's Investments case at 44 and 51.
It's also what Kelly and Cooper
Yes.
says.
Oh, that's right. But that's the ambit and scope of the solicitor's fiduciary duties are generally circumscribed by the contract, and that's the Children's Investments. There's the Kelly and Clark. There's also a
Kelly and Cooper.
Clark,
Boys.
and there's Hilton and Baker Booth, which is another Privy Council decision, Lord Walker, which is at divider 22 of one. Generally, we would submit a solicitor will owe no fiduciary duties until there is a concluded retainer. There may be circumstances in which a solicitor might owe a fiduciary duty to a prospective client before a retainer is formally concluded. For example, take the secret commission case. If the solicitor is negotiating with a client and there is he or she is going to get a secret commission for the client's instruction, and the solicitor then does work prior to the formal conclusion, it might be said, well, hold on, there's the fiduciary duty owed in relation to that secret commission in those circumstances.
But there always would be. I mean, if a solicitor takes a secret commission, they're not allowed to at any point.
No.
In the relationship with the client, full stop.
Well, you're not. Yes, but I suppose what would
Doesn't
happen.
that put paid to your timing point?
Well, if the solicitor is negotiating with the client and has in mind to take a secret commission, the client then says, well, thank you very much, no, I'm walking away. I'm going to instruct your rival down the road. It's difficult to see that there's any breach of fiduciary duty there. It might be said that there might be an inchoate breach which doesn't crystallise until the client actually formally instructs the solicitor. But yes, I take Mr. Williams' point that there's a world of difference between a secret commission case, which is nigh on fraud on the one hand, and a case such as this, where the solicitor is negotiating the terms of his or her retainer with the client. As Lady Arden pointed out, in such circumstances there is a conflict between the solicitor on the one hand and the client on the other, because the solicitor, I can't remember what the phrase was, no reasonable expectation of self-abnegation is what Lady Arden said, but the client wouldn't necessarily expect the solicitor in negotiating the terms of the retainer to be looking after the client rather than his or her own financial interests. But one cannot, we would submit, under the guise of a fiduciary duty, impose effectively an obligation of good faith or full and clear exposition or informed consent on a solicitor when they're negotiating the terms of their contract.
Well, that's because you have to say what the informed consent is to. isn't it?
Yes.
So it's an obligation of informed consent is totally meaningless. What is the informed consent to?
Well, that's
And the informed consent here is allegedly to charge more fees than costs that will be recovered. And is that, what is that in terms of fiduciary duty?
That's right. It's not. I think my lord has it right. It's not it's not saying we will not charge fees. It sets out the amount of the fees, but what it is, it's a failure to explain that there may be, or fail to make clear that there may be circumstances in which the fees that I will charge will overtop the damages that you are likely to get.
You say it's not really a case of disloyalty, which is what fiduciary duties are about. It's a case of, if anything, just not giving advice, which is a sort of duty of care type.
Yes, it's a failure to explain the meaning and implications of the terms of the document that you have signed,
And I think
or you are going to sign.
I think there's authorities which say you can owe duties of care to people who are about to instruct you. If you give advice as to how their case can be funded, you can be in breach of that duty even before you take them on if you mislead them and so on. But that's not a disloyalty point.
No,
that's a duty of care point.
No, that's right. If you look at how fiduciary duty is explained, it's the duty of loyalty or the duty of
The whole foundation of the law of fiduciary duties, I understand it, is if you agree to act for the benefit of somebody else, you have to put their interest first.
Yes.
That's it.
Yes. And that's maybe I'm making it a rather ineloquent way. You can't, under the guise of that, if that's the basis of fiduciary duty, it's not what that is here. What is said is you have failed properly to explain the consequences or likely consequences or potential consequences of the document which you are about to sign. Because it's accepted that the document as a matter of contract permits the solicitor.
There's something inaccurate in it.
No, it's not.
Except possibly the word all, where it says you can recover part or all from the other side. But it's not.
Well, even that's not inaccurate.
No,
Because,
there are circumstances in which you can.
Yes.
That's the point. It
just doesn't give enough.
It just
Doesn't give enough information.
No, but that's the complaint. But
Yeah.
it's not a fiduciary duty breach at all.
Now, we've had a long day, Mr. Holland.
And
Would
I
you
do
like
feel I apologise.
Would you like to conclude your submissions briefly in the morning?
Yes, I would, and I will keep it as. It's not the morning; it's tomorrow afternoon.
It's the afternoon.
Tomorrow
At
afternoon.
1:30 p.m.
Yes.
for the avoidance of doubt. But we're doing pretty well, I think, aren't we, in terms of timing, because Mr. Kirby will get a fairly clean start tomorrow afternoon.
Yes.
And he'll have the time allotted to him, and you'll have plenty of time for your reply. Okay, well, thank you. Thank you all very much. See you tomorrow.